Welcome back to Family Law and More. In today's episode, we're going to be discussing navigating equity and emotion in divorce. Thank you for joining us today, Dan. Can you tell us a bit more about your background?
I can. I am a solicitor at AFG now, but I came to the law a little bit later than some of my colleagues. So previously, I've had a number of other hats on. That's included being a manager at victim support. So I worked from an office at Crown Square here in Manchester. I've also worked alongside probation. I'm working with offenders whilst they're reintegrated back into the community. And I've also had a few roles working in the housing industry, working directly really with vulnerable tenants, so around supporting them and their needs. So I think when I look at my peers, I do probably have a little bit more of a different background in terms of not just going from uni into a training contract and then going on to getting a position. So hopefully that lends itself to being able to provide and recognise support needs when a client comes through the door.
And if we take it from the start, Dan, when a client first presents themselves to you explaining that they're wanting to get a divorce, especially based on your background and your understanding of the wider things that they may be facing at that time as well, how important is it that you are managing their emotions and also being aware of, outside of the divorce, what they're going through at that time?
I think it's absolutely key, isn't it? And I think it's become more and more prevalent, and thankfully so, that solicitors and professionals in the legal sector are aware of the ramifications around things like mental health, and recognising that every person who comes through the door is an individual, and it's not a one-size-fits-all approach. So you have to recognise, what their needs are really. So whilst you're always applying the law to their circumstances, and you want to provide them with the very best legal advice to enable them to get positive outcomes, you have to recognise that sometimes that journey can take a little bit longer, depending on the needs of the client. So I think that it's important to have some sort of matrix where you can recognise, those clients that might need a little bit of additional support, whether that's from me as their solicitor, or being able to signpost them to the multitude of professionals who are out there. And at AFG, we have very strong links, with different professionals, so we're able to, signpost clients so they get the very best support. Because I think it's really important to recognise that as a solicitor, you may have come across, certain sets of circumstances, but that doesn't mean that you're best placed to be able to provide that client with the very best advice to enable them to make, positive, informed decisions.
You referenced about clients walking in through the door. Does that still happen, as in post-pandemic? Are you engaging with clients more remotely? And if so, does that impact on that maybe initial screening, that read that you've got to undertake as to what they need from you, and if there does need to be that signposting?
Yeah, I think that post sort of COVID, there has definitely been a shift. So we're able to sort of conduct those initial consultations remotely. And that does happen, and we can take instructions from around the country. And we've got different office bases. But I always try and favour that one-to-one approach in a face-to-face capacity. Mainly because you can pick up on so much more when you're actually in a room with someone. So it's not just body language and sort of reading the room, but you can pick up on people's responses, I think, a little bit better. So I think that at AFG we have a process where we'll get that initial call, but then we ask the client to complete a questionnaire, and that will inevitably lead to being able to approach them directly and advise them what we think is the best approach. However, we're very mindful that we're taking instructions, so it's always up to the client if they would like to meet face to face. That is my personal preference.
Yeah, it's mine. What about you, Claudia? Do you find face to face with the client is better?
I always think face-to-face is better. I know post-COVID things have moved to remote hearings or remote conferences, but I think still nothing can beat seeing your client face-to-face. And as you say, it's a very emotional time for them. And I think being able to see their body language and support them in person, that is the best way forward.
Yeah, because that conversation that the client's having with the solicitor in that initial consultation, they're telling the solicitor things that, it's inevitably a very emotive time for them. But they're telling them about their lives, and very often it's the worst thing that's ever happened to them. They're losing potentially their life partner. They're having to make, huge decisions about how they're going to be financially independent moving forward. Very often, there's massive crossovers around childcare and how they're going to kind of be able to co-parent appropriately moving forward. So being in the same room as a client and being able to read their body language and their signals, and being able to say, look, potentially we can call it a day for today, and potentially make another appointment, because it's clearly been a difficult appointment. And it's about recognizing that, as I said before, everyone who comes through the door, you have to treat them as an individual and recognize that they've all got different issues. I think in family law, you tend to be working around, the same sort of legal aspects, but then adapting those responses and applying the law to each individual case is very different, isn't it?
And as you've said there, every case is different, but there's also the legal principles you'll be following at that time. When a client does present themselves to you, what do they need to come with, or are you able to provide timelines for different evidence and disclosure they need to provide for you to be able to progress the matter further?
I think it's important that you give the client some structure. So in that initial consultation, we'll explain what the processes are and what their options are potentially, and the different pathways that they can take. In terms of financial disclosure and potentially going down the issuing financial remedy proceedings route, we always explain that, ideally we don't want to do that. And the reason why we don't want to do that is because of the cost to the client, but also, the emotional cost to the client, because being in, contested, protracted legal proceedings, it's very often not beneficial to that family unit. So it's recognizing, that can we approach things differently? Can we tap into things, like alternative dispute resolution? Are there other options for the client? And unfortunately, mediation, although it's a really, really useful tool, it takes both parties to want to engage appropriately. So it's about explaining to the client that they have options, and explaining to the client that they're giving us instructions, and it's our role to provide them with as much information as possible so that they can make informed decisions.
I think from my side, it's really important for the client to have that positive engagement with their solicitor, with you from the outset, because certainly by the time it gets into court, if it ends up in that arena, a judge will not be empathetic or sympathetic that a client has felt emotionally overloaded to the extent that they haven't been able to get the bank statements or whatever disclosure is required. So I think the more solicitors can do with them sort of front loading it, has the benefit of hopefully avoiding court proceedings, but if it does go into court, then everything is ready and it should hopefully be a smoother process for all concerned.
Yeah, I agree, Lisa. I think that it's really important that clients are aware that, financial disclosure, it's quite an arduous task. If you're asking someone to complete a Form E, it's a comprehensive document. So it's about managing, their expectations, but potentially giving them timeframes from the outset, making it very clear what documentation they're going to have to provide. And that can be quite a shock to some clients. And when you're presenting them with a list of supporting documents and you're providing them with this, Form E, it can be daunting. So it's about providing them with enough support to complete that document, and allowing them that time, but also explaining that there is an ongoing, onus on them for full and frank financial disclosure, and that's the same for both sides. And it's because we want to understand the financial landscape, because as solicitors, we can't provide the client with the right advice, and then we can't, further down the line, give counsel the very best opportunity to get them an outcome unless we understand the financial landscape. So that will include, capital assets, pension, income liabilities, etc. And I think that, at the inset, very, very often clients are reluctant to provide all of that information because, again, it's kind of looking at their life, isn't it, and their lifestyle, and it's very personal. So it's about establishing a really positive relationship and explaining that this is a means to an end, and it's about getting from A to B, A being them coming through the door, B getting the most positive, fair, proportionate outcome for them and their families at the end of proceedings or at the end of constructive negotiation. And I think that one thing that I always say is that very often there'll have to be a compromise. Clients come in the door with red lines, they want to maintain their pension or they want to retain the family home, but it's about, I guess, measuring the reality of the situation when we understand what's there.
I always think it's, I don't know if interesting is the right word, but clients won't appreciate that time period between separation and then engaging with yourself and looking then at disclosure means that their ex-partner will have eyes on how they have been, living their personal life. And so you, I think, trigger something usually within that emotional fabric of the client and certainly become quite resistant and defensive about sort of their right to privacy, which I think sort of on a human level outside of the courtroom completely understand that. But there's a process, and as you say, the key is managing expectations and setting that time frame so we can just keep one foot in front of the other, just keep making progress.
Maintaining that momentum. And I always explain to clients that they're going to have some really bad days.
Yeah.
And it might be that they take 1 or 2 positive steps and then 3 back. But it's about ensuring that we keep on moving forward with a view to reaching a positive outcome. And very often when, I explain again to clients that, when a relationship ends, particularly a long-term relationship, people have been in marriages for a long time now. And that, I should rephrase that, people are getting divorced who've been in very long marriages.
Yes, yeah.
It isn't just, those parties that have been married for a couple of years. And it is very much like a bereavement. And they have to go through the stages that parties go through when someone dies, effectively. And people, approach that differently.
What do you say to clients about them leaning on family and friends who, again, on a human level, probably come from a very good place, well intended, but again, from our side, maybe creating some resistance, some barriers, some conflict in what the client is hearing, and then the client emotionally feeling very confused and conflicted because legally we're saying one thing, but family and friends are saying another. Do you have sort of general guidance you give clients in that situation?
I think it's always positive if a client can get support from family and friends, but we'd always guard against, those, midnight Google searches and relying on the friend from the pub who got divorced and, explains to the client exactly how he got the outcome that he wanted. So support in any kind of form is a positive. However, you have to guard against, potentially what's the added value of that support? Are they getting the right messages? So it comes back to that point where, as a solicitor, our role is to apply the law to their circumstances in order to, establish a positive outcome for the client. So I think that you would always kind of have that discussion with the client to guard against, negative influences. So does that answer your question, Lisa?
Yes, no, that's helpful, because I don't know about your experience, Claudia, but when we go to court and a client arrives with family and friends, you've very quickly got to take a read on the situation because we're under time pressure. The judge is going to be expecting us to do certain things by a certain point during that hearing. And if you've got family and friends in the conference room who, again, are there with the best of intentions to help and support, but you're then not having that direct conversation with the client because everyone's got an opinion on, you know, what should or shouldn't be happening, it can actually become quite a distraction. But you don't want to upset the client, especially if we're meeting them for the first time and one of our opening remarks is, well, no, that person can't come and sit and support you. So I know we're going to talk a little bit about how we as a profession collaborate and support one another, but certainly it always helps me if a solicitor gives that information in advance. Client is likely to attend with family or friend X and they're helpful, or you may want to, you know, gauge where they fit into those conferences. Have you had similar experiences?
Definitely. I think sometimes they can come with someone who's very helpful and will maybe give them a bit of a reality check about where things might be going and maybe to be a bit more flexible. But other times, like Lisa said, it is an emotive time and their family members may be not assisting in the way we would hope.
So I think I would always put in a brief to counsel who is going to be in attendance. And I think it's, you know, again, it's about weighing up what the added value of those extra bodies are. Because support is amazing for anyone who's in that arena. And I think we've got to remember that clients, they're not in there every day.
No.
So it's a very daunting experience going, you know, into court. You know, even stripping it all the way back and explaining to them, you know, it's not going to be like it is on the telly. You know,
for sure.
and just little things like explaining that if they would like a glass of water, that will be available. But they won't be able to do X, Y, and Z. And very often, you know, once you've explained that to a client and you've explained the differing roles of a solicitor and a barrister and how the interaction will go in court, it can help, you know, set them at ease, but also, I think, give them the confidence to go and attend, you know, whether that's the first appointment or the FDR. Because again, we've got to remember that this is the client's lives and this is the most important thing that's probably happening to them, certainly at that time, but maybe ever.
Yeah.
You know, we're shaping the futures of not only their financial independence, but also, you know, often the interaction with their ex-partner and the children, etc.
And as you say, Dan, they're touching on the relationship between solicitor and barrister. When as a solicitor do you decide it's necessary to instruct counsel, and even before hearings are initiated in terms of advice or conferences, what's your view on when to instruct counsel?
I hope you're going to say all the time.
All the time, all the time. And I think that it's really helpful, particularly in more complex matters, to, you know, get advice from counsel in a note and have that conference. Because I think counsel's engagement early on can help shape that end outcome. So, you know, certainly it's very worth tapping in. And I think it helps to develop relationships between the solicitor, you know, and the barrister. And I think that that's a really positive thing, and that can only ever result in, you know, a better relationship and better management for the client and their emotions. So it's really, really positive, even if it's just, you know, a friendly email. Because very often you don't have to actually instruct counsel to get a response, because you've got in mind that you will be instructing counsel at some point further down the track. So personally, I would probably do most of my first appointments, but I would, you know, potentially be instructing counsel beyond that point, depending on the matter. So I would explain, and at a very early stage, explain to the client what their options are. I think that, you know, obviously you have to be conscious of cost, etc. But yeah, it's about getting counsel involved as soon as possible, getting the right advice and helping to shape that final outcome.
Good. Thank you, Dan. I think we'll wrap it up there. As you've said, every client's experience is unique, and I think we could talk about this topic all day, but we'll wrap it up there. I hope the viewers have found this podcast helpful, and if they want to discuss this topic anymore, then they can go to the Unit Chambers website or contact Dan via the AFG Law website.
Right, thank you guys.
Thanks, Dan, for joining us. Thanks, Claudia.
Thanks, Lisa.
Thank you.
Bye.